Yes, be ready for the dictation. Start. The value of any freedom is determined by the extent to which the citizens are able to enjoy such freedom. Stop. Ours is a constitutional democracy, and it is axiomatic that citizens have the right to know about the affairs of the government which, having been elected by them, seeks to formulate some policies of governance aimed at their welfare. Stop. However, like any other freedom, this freedom also has limitations. Stop. It is a settled proposition that the right to freedom of speech and expression enshrined under Article 19(1)(a) of the Constitution of India encompasses the right to impart and receive information. Stop. The right to information has been started to be one of the important facets of proper governance. Stop. With the passage of time, this concept has not only developed in the field of law but also has attained new dimensions in its application. Stop. This court, while highlighting the need for the society and its entitlement to know, has observed that public interest is better served by effective application of the right to information. Stop. This freedom has been accepted in one form or the other in various parts of the world. Stop. This court, in absence of any statutory law, in the case of Secretary, Ministry of Information and Broadcasting, Government of India and others versus Cricket Association of Bengal and another (1995) to SCC 161. Stop. The states which are governed by policing and have a policy of greater restriction and control obviously restrict the enjoyment of such freedoms. Stop. That, however, does not necessarily imply that this freedom is restriction free in the states where democratic governance prevails. Stop. Article 19(1)(a) of the Constitution itself is controlled by the reasonable restrictions imposed by the state by enacting various laws from time to time. Stop. The petitioner, a public-spirited citizen, has approached this court under Article 32 of the Constitution, stating that though the Right to Information Act 2005, for short Act of 2005, is an important tool in the hands of any citizen to keep checks and balances on the working of the public servants, yet the criterion for appointment of the persons who are to adjudicate the disputes under this Act are too vague, general, ultra-vires the Constitution and contrary to the established principles of law laid down by a plethora of judgments of this court. Stop. It is the stand of the petitioner that the persons who are appointed to discharge judicial or quasi-judicial functions or powers under the Act of 2005 ought to have a judicial approach, experience, knowledge and expertise. Stop. Limitation has to be read into the competence of the legislature to prescribe the eligibility for appointment of judicial or quasi-judicial bodies like the Chief Information Commissioner, Information Commissioners and the corresponding posts in the states respectively. Stop. The legislative power should be exercised in a manner which is in consonance with the constitutional principles and guarantees. Stop. Complete lack of judicial expertise in the Commission may render the decision-making process impracticable, inflexible, and in given cases contrary to law. Stop. The availability of expertise of judicial members in the Commission would facilitate the decision-making to be more practical, effective, and meaningful, besides giving semblance of justice being done. Stop. The provision of eligibility criteria which does not even lay down any qualifications for appointment to the respective posts under the Act of 2005 would be unconstitutional in terms of the judgments of this court in the cases of Union of India versus Madras Bar Association (2010-11 SCC 1 full stop over.